I don't have any children. How do I go about asking a friend to be my power of attorney or my healthcare agent? I'm Sarah Siedentopf. I'm an estate planning attorney in Atlanta, Georgia. And this comes up quite a bit with clients who say, you know what, I don't have children. I don't have anyone who is sort of automatically assumed that they will take over these roles. How do I go about asking people? And the first thing that I do like to tell people is that there are professionals who do this. And there are various ways you can set that up. You can go, first of all, with a professional. You can say, there's nobody in my life who I either am that close to or want to put that on. So we can set you up, first. I have a list of people, and you can, you talk to them, you see who's a good fit for you, and, just hire a professional right off. The next thing is we could have a professional as the backup, and that is the most common thing where we say, okay, I do have a friend who I think would be willing to do this, but for, my peace of mind and to alleviate their concerns, we'll say that the professional is the backup. We could also have a where we say the professional works together with the friend. That is possible, depending on the professional's willingness to do this. If there are extra people making decisions, it always adds extra pieces in there. But knowing that there are professional backups available can take some of the angst off of that conversation. And really how do you communicate in that particular relationship is the real question, because there is a lot of value to asking face-to-face, sitting down, having coffee, having lunch, having dinner, and just saying, hey, this is what I'm looking at my estate planning, I'm trying to figure out what to do, I really don't have, family members available for this, is this a role you would consider? And I would, never put I need to know by Friday kind of deadline on it, because you want the real answer. This is absolutely a situation where you want the real answer. You do not want them to say yes when they mean no. And I absolutely have had somebody come into my office and say, so-and-so asked me to be trustee, and I should have said no, and instead I said yes, and they've passed away, now supposedly I'm trustee, how do I get out of this? And that's not the situation that you want. In this situation, the person had passed, but you definitely don't want your power of attorney, your medical decision maker, saying, actually, I didn't mean it. So you want the real answer. You don't want to come to them and say, I need an answer from my attorney by Friday. This is a big enough question that you want to ask it and give them space to say yes or no, to think about it, and work through it, ask questions, do some research on their own, because they probably want to know, what does this entail for me? On the other hand, if you are a texter or an emailer, there is also, I feel like, room for asking those questions, setting up those questions, maybe not having the whole conversation via text or email, but setting up the question so that it gives them a moment to think about it without looking you in the eye and having to make some kind of response right away, so that they can think about it, and maybe, if the answer is no, they can text it to you, and you're more likely to get an actual answer than if they're looking you in the eye and feel bad about letting you down. So it matters a whole lot how you communicate in the relationship. The biggest thing is to realize that you are looking for the actual answer. They are not your last and final hope. If you don't do this, no one will. We can find you someone who will do a great job, who you will like and trust, but it would always be, sort of more comforting if you've got a friend available. So when you're having that conversation, know that there are other options, and I think that is the biggest help to making that conversation flow smoothly. And of course, you can offer to pay these people. Power of attorney especially is something that I often, have payment provisions in for. So it's also an option for you to know that they can get paid, or to let them know ahead of time that, if you have to take time off work for this, you will be reimbursed, you will get paid for this. So that also helps. If you've got more questions about this, you need to do some estate planning and, think through what your options are for, limited family, limited trusted people. Please reach out. I'd love to hear from you. And also, thank you for watching, and please like and subscribe.
In this video, we're going to talk about at what net worth you should get a trust. Hi, I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. So, first question, what is a trust? A trust is an entity, so it's going to be a separate entity from yourself that owns property. The trustee, which depending on the type of trust, could be you, could be someone else, is the person that manages the property, and the beneficiaries are the people that get to use the property. So there are many different types of trusts. Revocable grantor trusts, where a lot of times you are both the grantor, the trustee, and the first beneficiary. But there are also irrevocable life insurance trusts, grantor retained annuity trusts, charitable trusts, all sorts of different trusts that have different rules about who's in charge and different tax effects. But the question here is, at what net worth do you need to be considering any of these things? And so the first thing to know is, right now, the estate tax is set at over $12 million a person, meaning that if you die with less than $12 million, or a couple dies with less than $24 million, no estate tax is happening federally or in Georgia. So everything gets passed however you have it. But in 2026, which is coming up closer than we like to think about, the estate tax is set to sunset. Now, many things could happen. Congress could pass any kinds of tax laws, but if nothing is done, the estate tax sunsets and goes down to $6 million a person, or $12 million per couple. So, as a base, we know that if you expect to die with more or right around $6 million, you should be getting tax advice, and you should be getting estate planning advice, and I would guess that that estate planning advice and probably the tax advice would involve a trust of some kind. So that's sort of if you're here, you should definitely be looking at a trust. But what about anyone else who is well below that threshold? Is there a point to having a trust? And at that point, the answer is, what do you own? Because if you own a house, your house can pass by right of survivorship if that's what the deed says. But most of the time, that's only going to hit the first level, so it passes to your spouse, but then when both of you are gone, suddenly the house is going through probate. So at that point, we really want to consider a revocable grantor trust just for probate avoidance, regardless of whether you are worried about estate taxes. Basically, people of all net worths may be considering a trust. One of the basic fundamentals is, do you own a house? And if you own a house, it is strongly worth considering.
How do you put your home into a trust? I'm attorney Sarah Siedentopf, and that's exactly what we're going to be discussing in this video. How do you put your house into a trust? So the very first part of this is obviously that we have to have a trust. What is a trust? A trust is a legal document that sets up a grantor, sometimes called a settlor or something else, but you put your stuff into the trust, and you choose trustees to manage the trust. That can be you, that can be someone else, depending on the type of the trust, but there's a trustee or trustees managing the trust. And then there are beneficiaries who get to use the things in the trust, and those, that beneficiary might be you, might be someone else, might be, you and your whole family, and then of course after you've passed on, it's going to be, whoever you've chosen. But it is a legal document, a legal entity,
and you're going to have it, signed, witnessed, notarized, so we've set up a trust. So after we have a trust, how do we get that house into the trust? And this is going to be an actual transfer of deed from your name to you as trustee of the trust, or whoever is acting as trustee of the trust. And so in Georgia, it is important to say so-and-so as trustee of the such and such trust, as opposed to just the such and such trust. And it's not fatal at this point if it's not done that way, but that is the preferred way of doing it. So you will have a deed, and it does have to be notarized, and there has to be a witness transferring the house with full legal description, and basically very similar to what you signed when you bought the house. You have a deed transferring the house into your name, and then now you're doing a deed transferring the house from your name to the name of the trust. That has to be filed with the land records here in Georgia. That's going to be in Superior Court for the county that you live in or that the property is located in. There will also have to be what's called a PT-61. That's a tax transfer document that needs filed so that they can make sure that they've properly calculated the taxes for the transfer, depending on what type of transfer it is. A trust, transferring your property into your trust, is usually going to be a gift. So it's most of the time, unless there is a sale or something else related there, a lot of times there is not a transfer tax, but the tax document has to be, done and filed regardless. And then once that has been done, you'll get it marked by the clerk's office, as filed. And that is what has placed your home into your trust. And now, you may wonder and may have heard that there's a possibility that putting your house into your trust may cause a problem with your mortgage. And that can be true depending on what type of trust you have. But if you have a revocable grantor trust, where you are the grantor, you are the trustee, and you are the initial beneficiary, so it's very important that you be the initial beneficiary during your lifetime. But as long as that is true, there is a specific federal law that prohibits mortgage companies from calling the mortgage, aka telling you it's due immediately. So there will not be a problem with transferring it into this specific type of trust. If you have a different type of trust in mind, obviously you're going to want to consult an attorney and make sure that it's not going to cause a problem with your mortgage. In this video, we're going to discuss when you should update or consider updating your estate plan. I'm attorney Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And I'm going to tell you about 7 times that I think you should consider updating your estate plan. And so the first one is if you got married. So it's incredibly important to understand that if you have a will from before your marriage, as soon as you get married, that will is completely messed up. It's not entirely revoked, but the court assumes that you forgot to change it, and so, the new spouse is getting, no less than a third, depending, maybe more, depending on whether there are children, and so it's completely messed up. So, if you've gotten married, update your estate plan. If you've gotten divorced, update your estate plan. So, if you have an estate plan that happened during marriage, when you get divorced, the court assumes that you no longer want, your ex-spouse to be acting as your executor, and so proceeds with pretending that that person has passed away, and everything sort of occurs as if they have already passed away. And so this is not quite as bad as what happens if you get married after a will, but it can cause a lot of problems, and it does not fix beneficiary designations. So beneficiary designations on your life insurance, on your IRA, on your whatever, if those don't get updated, it's still going to the ex-spouse. So as part of your whole estate plan, these are things we need to look at. Birth of your first child. This is another time that we need to look at updating our estate plan. Also a time when the court assumes that unless you could say, and you can say in your will, in your trust, that this was done in contemplation of children, contemplation of more children, and then it will stay. But usually the court assumes that you, again, just forgot to update and you would have wanted them to get a share and sort of rewrites it for you. The next time is when you have more children. So subsequent children, and this may not be a time that you actually need to update it. What you need to do is check and make sure that the wording is correct, because we're going to have a problem if it says everything to child 1. Then the court's going to get involved and rewrite things, because again, they assume that you really meant to include child 2 and you just didn't get around to it. On the other hand, if you look at your documents and they say, equal distribution between, child 1 and any subsequent children that I have, you're good to go. We've already covered, and the court can see that we have, prepared for any subsequent children. Another time that you really need to look at your estate plan and definitely need to update it is changes in relationships with the important people, the person you've chosen as trustee over money, the person you've named as executor, the person you've named as your power of attorney if something happens to you. If these people are no longer close to you, maybe you're no longer friends at all, or maybe they've moved away out of the neighborhood or out of state, they wouldn't really want to do the job, you want to choose someone else. Don't leave that to chance. Don't wait. Go ahead and update it. The same thing if they've actually passed away. When someone important in your plan passes away, whether that is, someone who you've chosen as, executor, trustee, whatever, or a beneficiary. If an important beneficiary passes away, we want to rewrite, make sure that the correct person is inheriting whatever it is that they were going to inherit. Do we just want it to go straight to their kids? Is there someone else that, did they have kids? Is there someone else that we want it to go to? And then the last big one, and I do say big one because, much like marriage, creating a blended family, and it's might even be considered a subset of marriage. But when you create a blended family, it's not just as simple as what is new spouse going to get. We have to think about my children, your children, our children, who's getting what, under what circumstances. How do we make sure that what we've planned stays in place? So those are 7 times that I think you need to either amend your estate plan, or at the very least go through it and make sure that it's still valid and it still covers the situation adequately. So if you've got questions about this, you've got an estate plan that has been around for a while and you're wondering if maybe it needs a look at, please do give me a call. But thank you for watching, and if you've enjoyed this, please do like and subscribe.
In this video, we are going to discuss distribution of assets to your beneficiaries. What are your options? Hi, I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. So, trust distributions, pretty much the sky's the limit for what your options are. We can do almost anything. One first thing to know is we can base it on particular standards of care. So the classic one we call HEMS, which stands for Health, Education, Maintenance, and Support, meaning that the trustee is able to make distributions to the beneficiary for their health, education, maintenance, and support. So if you think about that, that covers quite a bit of ground. It probably doesn't cover a Ferrari, and we might have to, think about where a vacation falls in there. Perhaps it's just maintenance, but that covers quite a bit of ground. And this is the classic fallback option. But you can also write your own standard.
basically anything you want. There's certainly standards that are just welfare, so for the welfare of this beneficiary. But if you have a specific idea in mind for what you would like to be covered under what circumstances, you can make the standard anything you want. It just has to be something that someone else can look at and understand as they are trustee. It can also be based on ages or milestones. So often we have trusts that say we're holding things in trust until such and such a person is 35. Or perhaps we are holding things in trust until they are 25, at which case we're giving them a third, and then another third at 30, and then all of it at 35. Or, we can of course change the ages to anything you want, because some people are comfortable and say, you know what, I really only want this held in trust until my child turns 21, and after that, have at it. Although I do encourage people to think about a 21-year-old getting all the help that they're going to get from you. Is this a great idea? We probably want to stagger the distributions. Well, we can also base the distributions on life happenings. So it can be a distribution when you graduate. It can be a distribution for the purpose of buying a house, for the purpose of starting a business. It can be a distribution for the purpose of having a wedding. Whatever things you would want the trust to pay for, the trust can do. We can also have the trust money in trust forever. Usually in that case, we have the standard of distribution, maybe just the health, education, maintenance, and support, so that the trustee is always able to make distributions for those purposes, but at no point is the beneficiary going to get their hands on a cash chunk. So really the sky is the limit to what you can do as far as beneficiaries and distributions. A very popular one with clients in my office is, the 25, 30, 35, where we're giving chunks at different times. And we also usually make sure that there's something coming out at either 21 or college graduation, some small gift. And small really tends to depend on the size of your estate, because what's small to one person might be quite a large chunk of the estate to someone else. But making sure that your beneficiaries have some money at their disposal for fun, but also have a responsible adult making plans about how the money is invested and overseeing expenditures until your beneficiary is old enough to do that themselves. So if you have questions about your options for beneficiaries and how to distribute things in trust, I would love to talk to you, and thank you very much for listening, and please like and subscribe.
I'm Sarah Siedentopf. I'm an estate planning attorney in Atlanta, Georgia, and we work with a lot of pet lovers, and so this is something that we run into on a fairly regular basis, is the question of, I would like a caretaker to move into my house to take care of my pets after I pass away. Do I need some kind of contract? If I want to make sure that my pets are not going to a shelter, there's not someone specific that they're going to, I want somebody to come into the house and take care of them, have them continue to live where they have always lived. No, you don't need a contract. Usually in this situation, what we are thinking about is a trust. And we specify in the trust, we put your house in the trust, and so then whoever is the trustee is in charge of this. And this does not mean that the person you want feeding your cats has to be the trustee of your trust. It does mean that the trustee of your trust is going to be in charge of, paying for the cat food and paying any expenses of this person, and if you've decided that they should get paid for their time, making those payments as well. So it can be a separate person and often a list of people who might be available to take care of your pets in the home, and that can be a different person than is the trustee in charge of your money and your assets. A trust is better than just a contract. The benefit of a contract would be sort of in addition to it. If you talk to somebody and you wanted to come to an agreement ahead of time about how much they were getting paid for this, yeah, you could totally have that and have that as part of your estate planning. But if all you did was, have a contract with someone for, their services and didn't have your house set up in a trust, didn't have those other instructions in the trust, it's probably not going to work out. So it's not sufficient just to have a contract with the person who would take care of your pets. It needs to be, part and parcel of your other, full estate planning to make sure that resources and your house stay available for your pets.
Estate planning questions. What should you know before contacting an attorney? Hi, I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And this one is fairly easy because you don't have to necessarily know very much before starting the process and contacting an estate planning attorney. The first thing you do need to know is, what are your goals? Why are you contacting an estate planning attorney? What are you hoping to achieve? Because if you can clearly articulate what you want to achieve, they will be able to help you do that much more efficiently and much more effectively than otherwise. The second thing that you do need to know is, what do you own? So in a general sense, we need to know what is the net worth of your entire estate. But in a specific sense, we need to know what types of assets are we dealing with. That doesn't mean that you have to write down all of the account numbers and all of these nitpicky details before meeting with an estate planning attorney. But it does mean that you should have a general overview of what do we own and what is it worth in a large overview sense. The last thing that you have to know is, who are your family and your loved ones that you are hoping to benefit? And sometimes the answer is, my family and my loved ones are different people, and that is something that we'll need to communicate to the estate planning attorney so that that attorney can figure out, are we going to have any conflicts? If so, how do we avoid these conflicts? But in general, knowing who it is that you want to benefit because they are your loved ones, your relations, that sort of thing is very important. So what are your goals? What do you own? And who do you love? It's a pretty simple setup process for what do you need to know before contacting an estate attorney.
In this video, we're going to talk about how to keep your vacation home in your family for generations. Hi, I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. So, how can we keep the vacation home in the family for generations? Maybe your grandparents own it and now you own it, and you want to make sure that your family keeps it and can enjoy it for a long time to come. So there are lots of options, but here are some of the major ones. So a first, what I will say is perhaps easy choice, is going to be putting the house in trust and designating who can use it. We would put a trustee in charge, whether that could certainly be a family member. It could also be a professional trustee company so that we could, make sure that there's, people on down the line taking care of this. But at the same time, in this trust, we need to have money for the upkeep of the property. So that's the first option, is putting the property in trust for, here in Georgia, it could be up to 360 years, but also funding the trust with assets to pay for the taxes, the upkeep, all of the maintenance on the property over that time period. A second option that also involves a trust is going to be a qualified personal residence trust. And so that has some tax advantages, but basically you put the property into the trust for a certain length of time, and as long as you, as the original owner, outlive that length of time, at the end of the period you have chosen, the property passes on to your beneficiaries. So you no longer own it. At some point, it does pass to someone other than yourself, your family members, but there is a discount for tax purposes on the gift. Because the gift is, so far out, you do get a discount on that. So this is a popular way to pass on a house to the next generation. Another option is a family limited liability partnership, family LLP, putting the vacation property into that business entity and having family members as shareholders in the corporation. So that can last, for as long as you want to. With this, again, you're going to want to think about how are we funding the property, because if we just dump a vacation home into this business and there are no other assets, who is paying the taxes? Who is paying for upkeep? What happens when we need to repair the steps? Who's paying for this? And so that's a big question even before you start thinking about how are we going to pass this on, is who has the money to finance this? How are we going to finance a long-term, maintenance of this property? Because if you own it, you're paying for the upkeep. But as soon as you pass it on to, your children, if you have multiple children, then we're likely to have arguments about who can use it and when, who gets the good dates, who pays the taxes. I'm mad because you took it over Christmas, so I don't want to, contribute for, the maintenance on the roof. Or maybe I just don't have it, and so one of the beneficiaries has to pay for the roof just because they have the personal means to do so, and it isn't fair. And at some point, the not fair might even just be so much of a burden that the property has to be sold, which is, of course, not what your plan was. So it is very important to talk to your family members about who has the means to keep the house up and who has the motivation to do so. You may have family members who really, really love the property, and a better plan would be to pass it on to that specific family member and let them know that you really hope that they allow the other extended family members to gather in this home at some point, but pass it on to the person who is able to take care of it. So there are a lot of options for keeping your vacation home in the family for generations, but you really have to work out what is the best situation for your family and how are we going to fund it.
In this video, we are going to try to understand inheritance taxes. I'm attorney Sarah Siedentopf. I practice estate planning and probate in Atlanta, Georgia. So, inheritance taxes, also known as death taxes, very cheerfully. The first thing to know about them is Georgia doesn't have one. So we're only worried here in Georgia about federal taxes. Federal taxes right now, in 2023, only kick in when the person passing away is passing over $12 million. It's rising each year until we get to a certain point, and then the taxes are sunsetting if the law doesn't change. But right now, it's $12 million, a little over $12 million that are passing tax-free. And if it's a married couple, that's $12 million apiece. So, 24, it's, talking $25 million that can pass before any taxes come into play. Above that, so if I have $15 million to pass when I die, the amount over that does get taxed. That's where we're running into inheritance taxes. And the tax rate's about 40%, so it is fairly hefty. But I got to give away over $12 million before I ran into taxes. So again, here in Georgia, we don't have state inheritance taxes, and federally, you have to have a fairly sizable estate before you run into that. And of course, if you know that you do have a sizable estate, taxable estate, or are likely to in the future, there are some things that can be done, planning that you can do during your lifetime to mitigate that to a certain extent. And so I would love to hear from you if that's your situation, but that's inheritance taxes and understanding them. Should I leave money to the person that I am leaving my pets with after I die? I'm Sarah Siedentopf. I'm an estate planning attorney in Atlanta, Georgia. And I often think this is a great idea. If we're giving a pet, we are giving a responsibility. Pets cost money. If you have the funds available, that is an awesome idea. How much you want to give is very much up to you. You can, think about, life expectancy of the pet and do a yearly amount. You can do a, small gift, a large gift. You can do it outright. You can do it in trust where somebody else is in charge of the money and whatever's left over goes somewhere else, as opposed to outright that is a gift to this person and they get to use it however they want, regardless of whether they need it or use it for your pet. But yes, if you have the funds available, a gift eases that transition for them. They've probably got supplies and changes they need to make. Always a good choice. And if you have a pet that you think might be going, to a shelter or something like that, if you leave some money, we can, often have it be a donation to a better rescue who is, more likely to take good care of your pets and find them a good home. Just know that when you are leaving a gift to a specific person, not in trust, but just a specific gift, my dog to my sister and, $5,000 to her, she gets to keep that money even if she gives the pet to someone else. So that would be the benefit of the trust if you have questions about how that money would actually be spent. But in general, don't take money from your children that you don't have to give. But if you have the money, it's always a kind and appreciated gesture to give some, thank you money for the fact that you're going to be changing your life, and I appreciate it.
Do you need a will if you have a trust? This is an excellent question, and it shows up a lot in my office, particularly because when we're talking about trusts, people assume that they don't need a will and don't understand why I'm recommending both. I'm attorney Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia, and you may have just guessed, my answer is yes. You need a will even if you have a trust. One of the first reasons is that only a will can designate the guardian for your children. So we can't put that in a trust, it won't be effective. But maybe you don't have minor children, and so you think, okay, trust only, got it. You still need what's called a pour-over will. And this basically says, if anything got left out of my trust, run it through probate as quickly as possible and dump it into my trust. And so more or less all it does is tell the court who it is that you want to be in charge. Obviously, if you have children, you're going to designate the guardian in that will. But in general, this is a very, very short document because all of your instructions are in that trust. When would this come into play? The goal for pour-over wills is that we never need them. They do not get probated because there is nothing to probate. The goal is that we got it all into the trust during your lifetime and nobody has to mess around with probate at all. Sometimes that doesn't happen. And sometimes that's because you moved, bought a new house, something like that. We didn't transfer it into the trust. And you're thinking, well, I will stay on top of this. I do not need a will. I'm getting this handled. But there are also situations where things arise after you've passed away, such as insurance settlements for wrongful death claims, things like that, that might belong to your estate, and suddenly there is money in your estate that is not in your trust, and we have to go through probate for it. So it is always good to have a pour-over will, even if you have a trust, because if you don't need it, you don't need it, and that's awesome. But if you need it, it helps things move more quickly through probate, and your family will appreciate it.
In this video, we're going to talk about at what net worth you should get a trust. Hi, I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. So, first question, what is a trust? A trust is an entity, so it's going to be a separate entity from yourself that owns property. The trustee, which depending on the type of trust, could be you, could be someone else, is the person that manages the property, and the beneficiaries are the people that get to use the property. So there are many different types of trusts. Revocable grantor trusts, where a lot of times you are both the grantor, the trustee, and the first beneficiary. But there are also irrevocable life insurance trusts, grantor retained annuity trusts, charitable trusts, all sorts of different trusts that have different rules about who's in charge and different tax effects. But the question here is, at what net worth do you need to be considering any of these things? And so the first thing to know is, right now, the estate tax is set at over $12 million a person, meaning that if you die with less than $12 million, or a couple dies with less than $24 million, no estate tax is happening federally or in Georgia. So everything gets passed however you have it. But in 2026, which is coming up closer than we like to think about, the estate tax is set to sunset. Now, many things could happen. Congress could pass any kinds of tax laws, but if nothing is done, the estate tax sunsets and goes down to $6 million a person or $12 million per couple. So, as a base, we know that if you expect to die with more or right around $6 million, you should be getting tax advice and you should be getting estate planning advice, and I would guess that that estate planning advice and probably the tax advice would involve a trust of some kind. So that's sort of if you're here, you should definitely be looking at a trust. But what about anyone else who is well below that threshold? Is there a point to having a trust? And at that point, the answer is, what do you own? Because if you own a house, your house can pass by right of survivorship if that's what the deed says. But most of the time, that's only going to hit the first level, so it passes to your spouse, but then when both of you are gone, suddenly the house is going through probate. So at that point, we really want to consider a revocable grantor trust just for probate avoidance, regardless of whether you are worried about estate taxes. Basically, people of all net worths may be considering a trust. One of the basic fundamentals is, do you own a house? And if you own a house, it is strongly worth considering.
What are the pros and cons of putting rental property into a trust? So, not a discussion of your personal residence, not a discussion of your vacation residence that you're keeping for your own personal and family use, but rental property, something that you are letting others pay you to stay in. So please stick around for discussion of that. I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia, and author of the book Peace of Mind Through Estate Planning. What are the pros and cons of putting rental property in our trust? You're going to want to find out because you don't want to be making any mistakes with what is supposed to be a money-making property. So the first thing that we're going to discuss is a con of putting rental property into a trust, and that is no liability protection. Trusts are not designed to give liability protection, particularly in Georgia, a very creditor-friendly state, and so we're not getting liability protection with the trust. On the other hand, as a pro, we are avoiding probate. Probate takes time, costs money, and is generally a headache and a hassle. So if you pass away, you are avoiding that hassle for your family. The asset can be transferred under whatever the provisions are in the trust without worrying about that. Another pro is going to be the backup trustee. So if something happens to you, whether that is that you've actually passed away or whether you are incapacitated for some reason, we have a backup trustee who is stepping in. Sometimes it might be a child, a friend, it could even be a professional, who's stepping in to manage the assets in the trust. So you know that there is a continuous management plan and nothing is falling through the cracks. Another pro of putting your property into the trust is that you can give very specific instructions for what should happen. If something happens to me and I can no longer manage the property, maybe I'm, no longer able to go out and mow the grass and do all the things that have made this lucrative for me, I can say, that the backup trustee should be selling the property and maybe investing in something different or doing whatever it is with that money. So I can be very, very specific about what the trust should do with the property. Con, no liability protection. Yes, you heard me say it before. It is the biggest con of putting your rental property into a trust. So there is a fix for this. LLCs are intended to give liability protection, so limited liability company. Anything in that LLC, if used properly, is sort of a bubble, and if there's any liability attached to that asset, somebody trips and falls at the rental property and sues you, if everything is done correctly, all of that liability stays inside the LLC bubble, and worst case scenario, we are losing that rental property, but we're not losing your primary house or your other assets. So we love LLCs for liability protection, and guess what can own an LLC? A trust. So often the combo of trust owning LLC, which owns rental property, is a great way to go and fixes those cons of a trust owning the property outright. I do this a lot. It's often very, very effective, works great for people. And so I do strongly encourage you to think about liability protection in regard to any rental property, insurance, but LLCs as well, and trusts for probate avoidance, but not for liability avoidance. So thank you, and please subscribe if you are interested in more content.
DIY second marriage inheritance issues. What kind of things do we run into when people do their estate plans themselves? I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. And here are a couple of the things that I see quite a bit. And the first one is not considering a prenup. Of course, a prenup does many things, but it doesn't mean that you don't love someone. It doesn't mean that you don't trust someone. It just sets some expectations. And from an estate planning and inheritance expectation, usually what it says is, my stuff is my stuff, your stuff is your stuff, and we don't have claims on each other's stuff when we die. Now, this does not mean that you cannot leave things to your spouse in your will, but it does mean that they can't grab pieces of it that you didn't intend for them to have, because we've got the prenup that says legally you can't do that. You have waived your right to do that. The next issue with DIY a second marriage inheritance is forgetting to update those beneficiary designations. If they have not been updated since your first marriage, if they have not been updated since your children became 18 or older, if they haven't been updated to reflect trusts that you've put in place or anything else that has changed, it is likely to throw your plan completely off kilter. The last one that I see, and this one causes a lot of friction, is leaving the new spouse in control of money for children from your first marriage. You love your new spouse. You trust your new spouse. And sometimes it has been an incredibly well-blended family. Your kids get along with your spouse. Everyone is very happy. But often it leads to a lot of friction when someone who is not my parent is in charge of the money that my parent left for me. And there can be questions about, are we trying to save this money for the spouse? Are we trying to, when should the children get it? And we want to make sure that if you leave someone in charge of money, it's someone who is well positioned to be fair to everyone. So you are often not going to want to leave your second spouse in control of money left for children of your first marriage. That can cause tons and tons of issues. If you have more questions about beneficiaries and other inheritance issues with a second marriage, I would love to answer them. And please feel free to also comment. Thank you.
Does Georgia have an estate tax? I'm Sarah Siedentopf. I'm an estate planning and probate attorney in Atlanta, Georgia. No, Georgia does not have an estate tax. There could be a federal estate tax that applies to your situation, even though there is not a state one here in Georgia. So if someone passes away living in Georgia, they are subject to federal taxes. However, there is an exemption, which means that up until I meet the exemption amount, I am not taxed. And right now the exemption is a little over $12 million per person. So I can give away at my death a little over $12 million before I run into any federal taxes. After that, they are taxed at a pretty hefty percentage, but we don't specifically have estate taxes in Georgia. What is the difference between a guardian and a standby guardian? I'm Sarah Siedentopf. I'm an estate planning attorney in Atlanta, Georgia. And you may not have even heard of a standby guardian. So this is something that we like to set up for people with minor children. When you're doing your other estate planning, we want to do a designation of standby guardian as well as your will. But what is the difference? The difference is the standby guardian, that designation is only active during your lifetime. The will names the guardian or co-guardians or the list of, guardians who are going to raise your children up to the age of 18 and probably take care of them longer than that if you pass away. So this is the person that if you die is going to take care of your children long term. And that person can live in another state. Sometimes they live in another country. It's the person that you think is the best choice for long-term raising your children. The standby guardian is a short-term guardianship that only kicks in if you are alive but unable to take care of your child or children. So you are in the hospital temporarily, you're going to get better, you're not dead, then the designation of standby guardian kicks in. So we've got a short period where this person can, authorize medical care, talk to the school. There's no question of, Child Protective Services, Children and Family Services having to do anything. You've already got someone chosen. And so can this be the same person as your guardian? Sure. But only if the person you are choosing as your guardian lives close. The big deal with designation of standby guardian is that you designate someone who can get there quickly in case of an emergency. I like to tell people within an hour, would I love for it to be within half an hour? Yes. This is the person that it's 3 a.m, you haven't come home, the babysitter has not been able to reach you, you're not answering the phone, babysitter's freaking out. This is the person that they call to be there quickly in the case of an emergency to take the kids. So can it be someone in another state? Only if you live close to the state line. It really is someone that needs to be there quickly in the case of an emergency. And of course, someone that you would trust to short-term take care of your children, but it's not the same level of long-term commitment. And so I do feel like proximity is a very important component of that choice, whereas who's the best overall choice regardless of where they live, is a bigger aspect of the, official guardian. So those are the differences between standby guardian and, guardian under the will. If you got more questions about this and want to designate a standby guardian, please let me know. I'd love to hear from you. And thank you for watching, and please like and subscribe.